Welcome. Thank you so much for logging on at 5 o'clock today, just in time for the Easter weekend. This is the homelessness update. Where are we now? Hosted by Garden Court Chambers. And I'm joined by my lovely colleagues, Stephen Cottle and Matthew Alawalia. Just a few notes from me to begin with. I'm Georgie. So this event is being live streamed and recorded, and it will be uploaded to our YouTube channel with the link in the slides that will be sent out to you after today's webinar. Please do put any questions that you have in the Q&A box, and our speakers will answer them at the end. So I'll be reading some of those out, and we'll be trying to get through the main themes, and I'm sure you'll have lots that you want to ask. So this webinar is aimed to provide an update of legal developments in homelessness over the last 12 months. And we're sure you're all very busy practitioners, as are our barristers at Garden Court Chambers. So it can be difficult to keep up to date with all the new homelessness cases. And so we want to help you get to grips with more recent case law. So firstly, I will be joined by Stephen Cottle. Stephen has been in practice for a very long time, and is an expert in social housing, planning and property law. He has established practice in housing, landlord and tenant, covering most areas, including and especially equality and discrimination issues, homelessness, possession claims, and mortgage repossessions, as well as housing standards and disrepair. Stephen was a finalist for the Legal Aid Barrister of the Year Awards 2014, and he is ranked in the Legal 500 and Chambers and Partners for his work in social housing. So, Stephen, firstly, I'll be handing over to you.
Good evening, everybody. We can see that there are a number of participants here, and I was watching a seminar by Michael Fordham J for the Planning Environmental Bar Association, where he told people not to taper off before it had finished, because that was very disheartening for the speakers. So try and stay till the end. But in fact, we thought we might go a little bit short this evening. Would like you to think about the questions that we could helpfully discuss at the end of this evening's session. And hopefully you'll learn something and might find a few points useful. So this evening, I'm going to talk about recent homelessness case law. But before I do that, here are some thoughts on where are we now. One of the headlines in answer to that question is that we're about to criminalize nuisance rough sleeping. I'm going to run through the case law, and then I'm going to come back to a case called Webb, Harden and Waltham Forest, and suggest that where we are now is that the equality duty needs reform. I know that there was a suggestion in Parliament of beefing it up, but it seems to me that the courts have not applied the basic discipline that is required of decision makers to be prepared to alter a decision to avoid an adverse impact where that's appropriate. So whilst the UK government indulges in politics that fuels the problem for the homeless, by contrast, the Welsh government are in the process of taking a completely different tack. They are setting an example we can all learn from by contemplating responsible, sustainable, long-term solutions with proposals for what's called a cultural shift to prevention. They think of extending a no one left out approach that they had during COVID and adopting a rapid rehousing policy to end homelessness with, can you believe it, repeal of the priority need test and removing the intentionality test from the legislation. And the consultation, although it closed in January, is a very worthwhile read. Criminalising the homeless. There are three measures that you want to familiarise yourself with. There's a sleeping direction, a rough sleeping notice, and a rough sleeping order. And the last two can both be appealed, but the direction can't. So it would be a JR. A prevention order can last longer than a notice, but that has to be made by the magistrate's court. And failing to comply is an offence and carries a possibility of a month in jail. I don't really see the effectiveness of fining those who are street homeless. So it's the threat of imprisonment that matters. And the most important point of this evening's talk, really, in terms of criminalising the homeless, is to understand that all three measures require the relevant person or the initiator to be satisfied that a nuisance condition has been met. So what is a nuisance condition? You'll have to read them for yourselves in clauses 61, subsection 2, 3 and 4 and the definitions. But what worried me was the definition in 61.3 that includes where a group is sleeping rough in a place and one or more does something that is a nuisance. And I was thinking about some of the areas, certainly around the South Bank, where you might find a collection of rough sleepers, and just one of them doing something that is a nuisance could jeopardize the rest of them there. And there's a problem of guilt by association. Another problem is the uncertainty over the extent of land comprising the place. Guess if there's a sort of 100-meter separation in between people are sleeping on the same section of pavement, if that's the same place. And then something that is a nuisance can include preventing determination of whether there's a health risk. So, people rough sleeping are averse to interference and people prodding them and trying to get their attention. And so I was sort of contemplating the scenario of let me have a look at you for the purposes of determining a health risk. And the person saying, no, F off. Would that be enough for criminalising the risk? The rest of them who are there. There are a few obvious statutory relevant considerations, but a less obvious one might be Section 1.5 of the Homelessness Act, which we used a lot in days gone by, but seems to have lost its traction recently, perhaps because some of them are so banal. But that section requires a housing authority to take their homelessness strategy into account in the exercise of their functions. So it's a breach of that duty not to do so. And the question I ask is how many will amend their strategy to refer to these new powers, and whether you can look to see whether they are actually complying with their own policies. And I suggest that the challenges, certainly for the JR and the direction, I don't know about the possibility of JRing the use of powers which have an ability to appeal, but there is a threshold issue as to whether the person is satisfied of the nuisance condition being met that could be subject to a JR, given the difficulties of arguing abuse of process in the criminal courts. But in terms of challenging a direction under the new powers, might be helpful to think about the judicial reviews that were brought in relation to the 1994 measures and the number of successful JRs that were brought against the police when they were deciding to move people on under those powers without having done proper welfare inquiries, without having actually looked at the consequences for the individuals. And the last point that I add is that in 1994, there was some quite helpful guidance that was issued regarding the pointlessness of bumping people on from one place to another where a greater nuisance might be caused. And so what I say is let's wait for the guidance because there may be litigation over the failure to follow that guidance. What I did was I went through Westlaw, the various sort of threshold duties, 175, 189, 191, 193, 210, so to speak, and just looked on Westlaw at the provision and the primary references to see the recent case law. And having looked at the recent case law, I then divided them up in between where the challenge had been upheld, which is the list here, and I've put the dates of the decision. So the first one is Welwyn Hatfield Borough Council, which is actually 4 years ago. But, the housing law reports began, I think, over 40 years ago. I think the decision that I remember from 1982 certainly was the sort of Parr and Ward Forest District Council, where the Court of Appeal comprising one Donaldson Evely, and I think it was one Denning, said that an applicant should be given a sufficient opportunity of considering an offer of accommodation. But even though it's 4 years ago, there's a basic point in that case. And I've listed the dates of these decisions going from November 22 right through to the Banner case, which came out yesterday, which Matt is going to talk to you about. And these are the cases in which the challenge was dismissed. And although you might optimistically be looking at the first list of cases, you might actually learn more from this list of cases. And I'm going to be running through the facts of these as well. There we are. So the Welwyn Hatfield Borough Council case, why did I put it in? Because I was thinking, well, recent in terms of 40 years of housing law reports, 4 years can occupy a space of being recent. But it's worth including the basic elementary point, really, as a premise to the talk this evening, that what is relevant is whether the facts on file were known and taken into account. And that really is the territory of the litigation that we have here, is whether the facts on the file were properly addressed by the decision maker. And then the Y.R. Lambeth case, elementary failure, really. No questions were asked about the children before an out of area placement was made. And I mentioned the Davidson case, which I find is quite an interesting one. And in fact, those of you who were attending previous talks, Garden Court Chambers, will have heard from our colleague Nick Bano on the test for interim relief. And he referred to a Liverpool case, an application of Houlihan, or rather the Houlihan was a litigation friend, talking about whether or not you have to have a strong prima facie case. And certainly it's a rumbling issue. And what was said in Davidson is the court needs to look at what is the least harm in either granting the interim relief and being wrong about that, or not granting interim relief and being wrong about that. And the point really is that it's at least arguable that Defalco and Crawley were wrongly decided in the light of the House of Lords judgment of Factor Army and the National Commercial Bank in Jamaica and Olint, which people will know about. So it's not necessarily the case that you have to have a strong prima facie case for getting a mandatory injunction. Now, Iman is probably the headline case of last year. And the question I was just discussing with my colleagues is how far this case might be carried across into other areas of law, because there's always been a judicial reluctance when a public authority waves the flag of financial considerations. And we've always known from private law, at least, that impecuniosity is no defence to a breach of contract. But we've always been a bit cagey in public law when it comes to challenging the budget, so to speak. And I know that in climate change litigation, there's a big question mark as to whether or not money is made available for public authorities to comply with their statutory duties. Well, bringing that down to the ground of housing law in Oman, the duty was owed and the breach of it was admitted. And so therefore the onus was on Croydon to comply with the duty. And the really headline news from the Supreme Court is the conclusion that it was not an answer for Croydon to say that it's expensive and not cost effective to comply with its duty. And those who have families with particular accommodation needs, that waiting a long time because the authority doesn't have the resources. And the question is whether the authority should go out of its way to make dedicated property available to those clients, should be using the Oman case. And there are a number of considerations that were discussed in that case, but I think it's all fact sensitive. And so I'm going to say no more than that, other than it is the headline case of last year. Now, in Saint Sepulchre, the decision was quashed due to an unfairness in the balancing exercise, a lack of inquiries, and a lack of reasoned consideration. So this was a JR of a 1883 decision. And so that is really quite a helpful case. And talking about unfairness, there's a case of St. Hilaire and Lambeth that's mentioned in the Legal Action Group Bulletin, Housing Recent Developments from January, where serious procedural defect in a review because the Housing Authority had not disclosed relevant information on file prior to inviting solicitors' written representations. And that reminded me of Henry Brooke, Lord Justice Brooke, as he was, I think, in 2005 in Auden, saying that where solicitors had requested the information that was before the decision maker, the review really shouldn't take place until that information has been provided and the solicitors have had a sufficient opportunity to make representations on the basis of the disclosure. A suitability challenge in SK and Redbridge, which I'm rather skipping over because of the pressure of time, but there was a single mother with 4 children, 2 of whom were profoundly disabled. And there was also a finding that the local housing authority had failed to produce a lawful assessment of the family's needs. And the South Oxfordshire case is interesting. Local solicitors, for some reason, put down South Oxfordshire when they should have put down Vale of White Horse. And the interesting argument from the housing authority was that there was no opportunity to amend the name of the respondent after the time had expired. And so the initial appeal was a nullity because it had been issued against the wrong respondent. And I was thinking as I was reading this case, well, surely that would have knock-on effect on the sort of standard directions that you get from county courts, which allow applicants to amend their grounds of appeal after disclosure of the housing file, but well after, of course, the claim was issued, because the directions are issued once it's in court. And it did have rather big knock-on effect, these arguments that were being presented. But the High Court decided that there wasn't any problem at all, and that it would really usurp the function of the court in upholding the rule of law. In fact, if the amendment couldn't be made under CPR 52 rather than under CPR 19. Now, this is where the going gets rough. This is where the challenges were dismissed. And this is perhaps the ripest area for learning most in this area of law. In the Rowan Haringey case, the decision that it was not reasonable to continue to occupy was in issue. The applicant's case that it was not reasonable to continue to occupy due to the number of people in the HMO, and there was complaints by adjoining occupiers about the children, and it was all to do with the number of people in the HMO. But what the Court of Appeal decided was only the room mattered for the purposes of deciding if it was overcrowded under Part 10. Now, this is quite an interesting decision on the relationship in between reasonable to continue to occupy and suitability. And it probably does repay a read. Yarbury, discharging the 1881 duty by advising the applicant to remain was irrational due to the fire safety risk of a wheelchair user not being able to escape in the event of fire. So why have I listed it under challenge dismissed? The reason the challenge dismissed was because 4 days after issue, there was a subsequent offer of alternative accommodation, which actually was rejected by the claimant. And so there was no remedy in that case, even though they'd been a prior breach. And in Bapty, this is a case where they were talking about reasonable living expenses. And should it be by reference to the guidance or to the actual position And His Honour Judge Hellman decided it was irrational for a local authority not to have used the amount of benefits which the applicant actually received and what the actual position was of her inputs and outputs. But that was overturned. And later in the year 2003, the Supreme Court has dismissed an application for permission to appeal. And so we get this rather arbitrary situation of the authorities deciding what somebody could reasonably spend by reference to guidelines rather than the actuality of what was in the pocket. And then the next case is Moj. And this is another case where the Supreme Court on the 30th of November, Lord Lloyd Jones, Lord Hambling and Lady Simler dismissed an application for permission to appeal. And in that case, there was late evidence which Lord Justice Snowdon said he was just persuaded to introduce in the Court of Appeal, which was not before the County Court. And basically, it was the Housing Authority's late evidence which swung the outcome, in that, according to their policy, the officers would be on the lookout for appropriate properties. And the case turned on showing that Ealing did not have any two-bed properties in its borough, the complaint being that the out-of-area placement was unsuitable because they hadn't sufficiently searched. And in Hodge and Folkestone, that's an interesting decision only because I think it's Lord Justice Elizabeth Laing who discusses the nature of accommodation and runs through Pulhofer, Awua and Ali. And you could learn a lot from reading those, although you might feel it's rather unreconstructed going back to Pulhofer on this. But the point is that the argument that since the room was not settled accommodation, Miss Hodge could not be intentionally homeless from it, was firmly rejected. And so this sort of halfway house that she was in, intentionality decision, followed from her deliberately leaving it, because if she'd stayed, it would have been reasonable for her to continue to occupy, and she might have then been, it was stepping stone accommodation on the way to which full housing duty could have been discharged. Now, the Ahmed case probably took me the longest to read, because there was a complicated procedural history with a permission granted by the Court of Appeal on a JR going on at the same time as a Section 202 and a Section 204. And you could applaud the solicitors as a fancy footwork, or the courts. But however, the Court of Appeal ended up seized of both the JR and the 204 appeal. And that procedural history is quite complex. There's quite a wrangle going on there. But the relationship between 189B and 193 is discussed, and there's a reference back to Roe on the interrelationship between accommodation that's not reasonable to continue to occupy and accommodation that's suitable, and the overlap between those two concepts, which people often feel they have to refer to in the same breath, whereas actually they're distinct concepts, each referring to their particular application, particular stage of the housing decision process. Now, the A, B, and CD case is interesting because there was a challenge arising from the local housing authority not having a property that could take a dog. And so the two people, the partners, were separated because they didn't have property for both of them and the dog. And I was surprised to read 20 paragraphs in the decision, the transcript, dealing with a challenge to the defendant's policy in respect of accommodating households with animals. And it's a peculiar case in that respect, and not very persuasive in my view. But actually, it does show how the issue of accommodation households with animals is dealt with, and it might be useful for you to know about that case. Now, moving on towards the end of the case law summary, the Webb Harnden and Waltham Forest case was a challenge to an out of area placement. And the Waltham Forest policy is set out here in the slide. Offers of accommodation in Waltham Forest or nearby boroughs are subject to affordable accommodation being available and the applicant being able to afford accommodation in those areas. If the benefit restriction cap makes properties in Waltham Forest and London unaffordable, then they will not be regarded as suitable. And it was argued that in effect, what this policy meant was that there was a practice of offering accommodation outside London. And I thought that really did follow. It seemed to me to be a very sound argument that in effect was what the policy was leading towards. And then it was further argued that actually what this meant in terms of whose benefits were capped was it would have an adverse impact on more women than men. And it may be that the effort and the concentration of leading counsel Caroline Monaghan in relation to the inequality in terms of the adverse impact on women took up most of the court's consideration because they gave short shrift to the points on the public sector equality duty. And it's the public sector equality duty, which is the subject, I think, of my next slide, if I may have that, please. So what the Webb Harnden case made me think is that the public sector equality duty isn't really doing its job. I was a consultant with the CRE following the Race Relations Amendment Act 2002 regarding race equality and gypsies and travellers. And what we were looking at was a system of public authorities monitoring their decisions and having data on which to inform themselves of the likely adverse impact, not just of policies, but of individual decisions, and then to see if that adverse impact could be mitigated, if not altogether avoided. And what Lord Justice Lewis, with respect to Lord Justice Lewis, in the Webb Harnden was saying is that really the public sector equality duty as a sort of process duty doesn't really require a different outcome. And of course, we were told that in Baker in 2008 when we were arguing the equality duty in relation to a borough which had no sites on which Irish travellers could go at all. And it was Lord Justice Dyson, who was the Master of Rolls at the time, who was saying it's not a duty to achieve a particular outcome. Well, that's right. But the point of the duty is to see whether an adverse impact that's been identified could be reduced or avoided. And the whole point of that, it seems to me, is to require the decision maker to see whether the situation could be dealt with differently. And that is a different outcome. And that discipline that's required of decision makers isn't really achieving the objective. And I read that there was some discussion in Parliament about beefing up the duty. But it seems to me that the equality duty is not working and needs reform, or it's being misapplied. And there's a recent government guidance on the public sector equality duty, guidance for public authorities, which we may want to have on your shelves. So where are we now? And it's not very happy reading. I say 309,000 and counting because I haven't included Wales there. The shelter statistics, slightly different from the government statistics. The government statistics are talking about 105,000. in temporary accommodation, and the shelter statistics talking about 279,000. And it may be that I'm misunderstanding the statistics, but it does seem to be a wide gulf. And obviously, with statistics, it's interesting to know how they're being measured. But whatever view you take, the fact that there are so many people in temporary accommodation and the fact that they're there for so long is really a compelling statistic that really requires the legislators to think about this, and which I go back to my first slide, which was the Welsh government's idea of rapid rehousing and the cultural shift that's required in this country from fending people off and excluding people to actually including and housing people. And you can say, well, that's a question of resources, but the length of time that people are in temporary accommodation really is indicative of a system that is failing. And so that's where we are now. And hopefully, after however many years of Tory and coalition government, the picture can be changed over the next 10 years. So thank you very much for me, and I'll hand over to Matt.
Thank you so much, Stephen. That was super comprehensive and great to go through both categories of case law, particularly when you were talking about the public sector equality duty. That reminded me that our esteemed colleague David Renton's new book, Discrimination in Housing Law, published by the Legal Action Group, is now available. And that has also got some comprehensive analysis of the public sector equality duty. So moving on now to Matthew Alawalia. Matt is a social welfare and public law barrister. He has a particular interest and experience in housing, homelessness, public law, welfare benefits, and migrant rights. Matthew's experience enables him to provide a holistic approach to clients, and he's an experienced tribunal advocate with particular expertise in universal credit, PIP, and employment support allowance. So without further ado, I'm going to be handing over to Matthew. Thank you very much.
Thanks very much. And thanks for the really helpful overview as well, Stephen. I think it's really good to have that kind of sort of big picture look at things in terms of where we are now. I'm taking a slightly different approach to my presentation and having a slightly deeper dive basically into a handful of the cases that some of which Stephen has identified earlier. So taking a slightly different approach. What I will say is, though, is that on the theme of the extent to which a local authority or other public body can argue that resources or finances are a factor in being able to meet their statutory obligations, which is obviously the sort of key thing that came out of Imam Croydon. We were talking about this and whether that might cross over to other areas of law, other areas of social welfare law and public law. And for what it's worth, I think if you open up your Fordham textbook, you'll see that there's quite a long history of the court being actually reasonably clear that the idea that absence of resources or financial difficulties is not going to be an excuse for not meeting your statutory obligations. So going back at least as far as the 1990s, a case of Tandy in Sussex, which is to do with a local authority's obligation to provide suitable education. So in that case, the court said that scarcity of resources wasn't a legitimate reason for failure to perform that duty. And some of you might remember from 2015, I think it was, Hotak and Southwark, the Supreme Court said there that an assessment of priority need under Part 7 of the 96 Housing Act is not to be influenced or affected by the resources available to the authority. So once somebody's status has been determined, their duty to that applicant, to that person, is defined in the Act. And the fact that the authority may be very short of money or available accommodation doesn't affect the assessment of whether an applicant is a priority need. So in that case, it's been dealt with already by the Supreme Court in Hotak. In other contexts, the courts have said that a desire to save money or to cut back isn't going to be justification for discrimination. So, for example, in the case of RF and the Secretary of State for Work and Pensions, which was a challenge to do with discriminatory regulations for personal dependence payment, the admin court there was very clear that the desire to save money is not a reasonable foundation for passing what was held to be a blatantly discriminatory measure. And the Supreme Court said similarly in the case of Cole and Secretary of State of Justice, saving costs might be a legitimate objective of public policy, but it's not something you can say to justify discrimination. So if you're going to limit a benefit, for example, in order to save costs, you have to do that in a way that is non-discriminatory. So all those authorities are well before the time of Imam and Croydon. I think why Imam and Croydon feels like it's particularly relevant is because of the current climate we're in, with so many local authorities facing increasingly difficult situations, lots sort of declaring bankruptcy and so on. So it's very helpful for the Supreme Court to be that clear on that point. It has come up in other contexts even more recently as well. So cases that have applied Imam and Croydon or refer to it, or sort of touched upon this idea that your legal obligations are not going to be sort of mitigated by a lack of resources if you don't comply with them. So even in the context of procedural obligations, the case of Montana and Lambeth, for example, Lambeth were found to have breached their duty of candor and cooperation in the process of that case. That was a JR about a housing allocation scheme. And the court emphasised in that case that public body may well be hard pressed and have scarce resources, but that doesn't excuse it from compliance with the duty of candor. So it applies not just to legal obligations in terms of what is in legislation, but also to your procedural obligations when conducting litigation. So yeah, it will make for interesting case or going forward, but I think it is worth just remembering that it actually shouldn't be too much of a surprise. It might just feel like it bites a bit more because of the precarious situation that so many local authorities are in. So that's my 2 cents on Imam and Croydon. I'm going to start the actual presentation now. So can I have the next slide, please? So first couple of cases I've kept within this kind of broader theme of assessments, PHBs, and inquiries. As Stephen said, there's lots of cases that we could have picked from. I've picked a handful to try and talk about in about 15, 20 minutes. I thought it'd be helpful to start with a reminder of what the statutory obligations are in relation to assessments and PHBs and inquiries and so on. And I've given you here an extract of section 189A about the assessment of the applicant's case. So it must include an assessment of circumstances that cause homelessness or threaten homelessness, the needs of the applicant, including what accommodation would be suitable, not just for the applicant, but for anybody with whom the applicant resides or might reasonably be expected to reside, and what support would be necessary for the applicant and any other relevant people to be able to have and retain suitable accommodation, all of which is expanded on in Chapter 11 of the Code of Guidance as well. So first case I wanted to talk about was UO and Redbridge, which is on this point about the importance of up-to-date, accurate, thorough housing needs assessments, because it will inform the rest of a local authority's decision-making when it comes to dealing with a homeless application. So UO and her 3 children applied as homeless after they were granted refugee status, and they were informed that their asylum support accommodation would be coming to an end. 2 of the 3 children attended a school in Tottenham in North London, and 1 attended a nursery nearby as well. What happened was they were told that their asylum support accommodation would end by the 8th of November. Towards the end of October, the claimant applied to Redbridge for assistance under Part 7, but it wasn't until the 7th of November, the day before, that the authority contacted the claimant back and told her that they would be provided with interim accommodation the next day, with no details about where they'd be staying. They were not asked about their housing needs either, so no kind of formal assessment took place, and certainly not one that was compliant with section 189A. As it happened, they were provided with a single room in a hotel that was 1.5 hours away from the school by public transport. They were then moved to another hotel that was even further away. And in the process of the homeless application, they were moved to at least, I think, to 7 or 8 different hotels in a 4-month period, none of which had cooking or laundry facilities. And expressing their concern about how the children were doing, the social worker wrote to the authority explaining and emphasizing that the eldest child in particular needed disability because they were doing well at the school that they were in and were about to take their year 6 exams, their SATs exams. And the head teacher of the school that they were attending also wrote in to explain their concern about how the kids were getting on, how they're performing. So all of this evidence was submitted, emphasizing, the importance of some stability and being able to stay in the area if they can, which didn't seem to have been taken into account. And after a pre-action letter was sent from the claimant solicitors, accommodation was offered, but this was even further away in Peterborough, and that would have required the children to change schools. Claimant refused that offer, and Redbridge discharged the main housing duty, which had been accepted by that point. So given that set of facts, may not be surprising that a judicial review claim was issued. And the 4 grounds, reasonably kind of predictable, you would think. So the initial unlawfulness of the housing needs assessment in the PHP, so insufficient inquiries made, didn't identify needs as you're supposed to do, an improper or an unlawful housing needs assessment would contribute to an improperly informed PHP. There was alleged to be a failure to take steps or to agree with the claimant the steps that would be reasonable to relieve homelessness under the PHP. And then there was a failure subsequently to review those needs, the housing needs, and the suitability of the accommodation that was being offered and provided. And rather unsurprisingly, the claim succeeded on all of those grounds. The court held that the local authorities' interactions with the claimant were wholly inadequate, didn't ask the right questions, didn't make the right inquiries, didn't follow up about the children's educational needs. A couple of passages that are quite important, I think, particularly in the context of what Stephen was alluding to in the sort of Imam and Croydon sort of world. There was a suggestion by the local authority in submissions that because the family had been moved around a lot in their asylum support accommodation, that somehow justified or mitigated the impact of moving the family again between lots of different hotels in their mainstream homelessness sort of context. And this is a paragraph 110 of the judgment. And I'm just going to read directly from it, actually, because I think it is quite good. What the judge said is that it is plain that the defendant approached matters from the wrong starting point, in that it had wrongly had regard to the history of the family whilst in asylum support accommodation, as in some way justifying the defendant's movement of the family between different hotels. That mindset was evidenced in the oral submissions. But as counsel for the claimant submitted, it was equally, if not more relevant, that in the light of that history, the claimant would be anxious to introduce some stability into the lives of her children. It also should have been obvious to the defendant that as a parent, the claimant could not reasonably countenance moving the children from school to school each time she was given accommodation in a fresh hotel. There is in any event nothing in the legislation or case law which permitted the defendant to benchmark the claimant's needs by a reference to what she'd been provided with pursuant to a different statutory scheme, which I think is really important, particularly because I'm sure all of us have had experience of trying to assist clients who are moving out of asylum support accommodation and are in that horrible sort of move on period. They've got their status, they're allowed to claim public funds, they're allowed to access homeless assistance. And then they're suddenly faced with a whole set of different problems from local authority or from the DWP. So I think that passage is really important. I've given you the paragraph reference there. So just because you've had a tough time with the asylum support accommodation, that doesn't justify unlawful treatment or being moved around a lot in a homelessness context either. Next slide, please. And then, thank you. So I've set out here, I hope it's readable, a few of the other kind of key passages from UO, one of which is directly related to the sort of Imam point about resources. So paragraph 120, the court said that accept that officials working in the housing department of the defendant and other local authorities are often required to operate under significant pressure. It's impossible to avoid the overall conclusion that the defendant has fallen far short of what Parliament has ordained. It is not for this court to usurp Parliament's functions by relaxing the intensity of judicial review in this area by reference to these and other pressures, such as the paucity of accommodation, to such an extent as to, in effect, rewrite the legal duties of housing authorities. So this is the court saying that what's in primary legislation is your obligations, and you can't say that lack of resources or significant pressures are an excuse for not meeting those obligations. And then a couple of other passages just to kind of underline, I suppose, the factual matrix of this particular case, but the wholly unsuitable nature of the hotel accommodation, impact on the children having to travel, nowhere to prepare meals or do laundry. And then at 138, since the defendant has failed to show that undertook any, let alone legally sufficient inquiries, the defendant can't simply rely on the general premise that there is an acute housing shortage in London. So again, there's a sort of allusion to Imam Croydon. You can't just say, oh, it's difficult. There's a housing shortage. There's a housing crisis everywhere. You're going to have to show some evidence of what you have been doing. It's not enough just to plead that kind of general sort of difficulty. So that's UO and Redbridge. Can we move on, please? Thanks very much. So the next case is similar sort of theme, still on housing needs assessments and PHPs and suitability. Stephen mentioned this, I think, in his slides, but I'm just going to go through the facts very briefly, which is it is actually, to be fair, far more complicated than I've put on the slide, but I've tried to kind of extract the key bits. So the claimant was a single parent who lived with 4 of her 8 children. The other 4 kids were adults. 2 of the children had significant disabilities. One of them was hospitalised at Great Ormond Street. But following treatment, her home was not considered to be suitable for her to return to because it wasn't wheelchair accessible. What complicated matters was that the defendant local authority obtained interim care orders in respect of 2 of the other children who were then placed in foster care. And then another interim care order in respect of the child that was hospitalised. Ongoing family proceedings is basically the key point here. But in the meantime, the claimant had already applied as homeless due to the unsuitability of her accommodation, was quite high up the priority banding in the housing allocation scheme, and the defendant had accepted that the main housing duty was owed to them under section 193. So important to bear in mind that the defendant had, in fairness, prepared an initial assessment of the claimant's case, produced a housing needs assessment and a PHP. These were updated on a number of occasions to account for the children leaving the family home as a result of the care proceedings, bearing in mind that these were interim orders that the family court had made. And the most recent version of the document, which was produced in November 23, although it wasn't sent to the claimant until a few weeks after that, was produced on the basis that the assessment only needed to consider the needs of the claimant herself and the remaining child. That's a bit of brutal language, but the remaining child that was in the household, and didn't account for the circumstances around the family had become. And so claimant sought judicial review on a number of grounds, including that the defendant had failed to meet its obligations in respect of lawful, up-to-date housing needs assessment and PHP for all of the children, remembering that section 189A requires that to be done for anyone who might reasonably be expected to occupy the household. And that was really the key basis on which the court found that the current most recent needs assessment and PHP were unlawful, because it didn't consider the needs of all 4 children. And it was plainly a possibility that all 4 would eventually return to live with the claimant. And rejecting the idea that you only have to do a lawful assessment at the outset and not do lawful ones if you choose to review them, or review becomes necessary. That would obviously lead to absurd results, such as in this case. So again, there's a need to be sort of mindful of those statutory duties and to keep things up to date and under review. Okay, so moving on topics a little bit. So moving on to eligibility. What I thought I'd do is just flag that there have been some changes to the eligibility regs in the last, well, there's been a lot of changes in the last few years really, but in the last 2 years in particular. You've got changes in relation to people from Ukraine and the various schemes that are around for Ukrainians in the UK under the immigration rules, as well as the other categories that I put out on the slide here. So it's worth going back to the eligibility regs and having a look at those if you're not familiar. So changes in relation to people with leave as victims of trafficking, people who have had to leave Sudan if they were living in Sudan before the 15th of April 2023. Then there's a potential eligibility route in there. Likewise, those who were residing in Israel, the West Bank, Gaza Strip, East Jerusalem, Golan Heights, or Lebanon immediately before the 7th of October 2023. So there's a different new class R for people in that category. As I say, always worth going back and having a look because these regs do get updated quite often. That's all I want to say on that. But I do want to talk a little bit about eligibility in the next case, which is on the next slide, please. And this is actually not a homelessness case. This is a case about benefits and access to universal credit. But because the eligibility rules around homelessness and welfare benefits are pretty similar, this is likely to have a bearing on the assessment of eligibility in a homelessness application. And I am told on the grapevine, somebody else in the session might know better, that we are expecting a judgment in a homelessness context that applies this case, this AT and DWP case. So it may be that everything I'm saying is going to be out of date by tomorrow morning. Hopefully not, and hopefully this will still be useful. And it is really interesting. So what happened here was AT was an EA national who was a single parent, a victim of domestic abuse, and it was established and agreed that she was not able to work. But she did have pre-settled status, which had been granted by the Home Office in December 2020. In January 2021, she had to move into a refuge, applied for universal credit and was refused by the DWP on the basis that she did not have a qualifying right to reside. So normally, pre-settled status by itself would not determine your eligibility for universal credit. You also have to have a qualifying right to reside in most cases. But what she argued was that without universal credit, she would be unable to meet her basic needs, particularly considering that she was not able to work and otherwise sort of improve her situation. And what she did was she relied on retained EU law under the withdrawal agreement and in the form of the European Charter of Fundamental Rights and Freedoms. In particular, Article 1 of the Charter, which is your right to human dignity. And I've quoted the text there. Human dignity is inviolable. It must be respected and protected, which goes a fair bit beyond, I would argue, the protections under Article 8 of the European Convention on Human Rights. So it's a little bit leaning more towards a kind of proper protection for socio-economic rights, which is why it was so important that the Charter remains in play. As it happens, AT was successful in the first tribunal, so at absolute first instance level, and the first tribunal found that they were bound by primary legislation, in particular the Withdrawal Act. They had to apply the Charter, and they had to disapply the secondary legislation, which would have excluded AT from being able to get universal credit. The upper tribunal then dismissed the DWP's appeal. So AT has won first tier and has beaten back the Secretary of State at upper tribunal level as well, and was also successful in the Court of Appeal, which held as follows, and as I set out on the slide. So Charter of Fundamental Rights continue to apply to the right of residence set out in Article 13 of the Withdrawal Agreement, which in itself incorporated the right of free movement of residence in Article 21 of the Treaty on the Functioning of the European Union. So that's your free movement rights. The test for whether there had been a breach of the right to human dignity provided for in Article 1 in particular was held to be the approach set out by the European Court of Justice in the case of CG and Department for Communities in Northern Ireland, which I'll come on to in a minute, about the requirement to conduct an individualized approach to assessing need. And the Court of Appeal said there's a positive duty on a host state which refused a form of relief to determine whether the applicant was in need of other forms of protection. And also importantly, worth noting that the Supreme Court refused the DWP's application for permission to appeal. So the Court of Appeal authority is what we've got. And it is very, very helpful. If we can move to the next slide, please. What this means in practice is that arguably anybody with pre-settled status without a qualifying right to reside could potentially rely on this judgment if the core facts are similar. And helpfully, both CPAG and the Upper Tribunal have provided really, really good, really clear guidance on how you might do that. As I say, this may well apply to homelessness cases as well. So if you've got a claimant or applicant who can establish that they have pre-settled status, they're unable to work, they don't have sufficient and regular support from a third party, no other adequate support from a local authority, and then an actual and current risk that they might not have sufficient resources to meet their basic needs, which could form, I would argue, we could include accommodation, then they might be able to argue that their a refusal of their homelessness application on eligibility grounds might violate their rights under Article 1 of the Charter, which I think is really, really important, really, really clear. As I say, the notes and resources on the CPAG website are excellent. They include template letters and witness statements that you can sort of borrow from. So definitely refer to those, and then put the links in the chat there. So yeah, really, really important, and worth keeping an eye out in case there is a judgment on the homelessness context. Okay, next slide, please. Thank you. So moving on a little bit to look at an intentional homelessness case, which is Kyle and Coventry. In this case, the applicant had a history of drug addiction. He had applied to Coventry as homeless and was provided with Section 188 accommodation in a hostel. At the time he was put there, he was taking methadone. He was said to have broken the rules of that hostel because he'd said it was said that he'd said he'd been admitting visitors and had been not been following the rules on smoking. So he's moved to a different hostel. The second hostel made complaints about his behaviour as well. And so he was moved to a third hostel, which was a property that was specifically designated for recovering drug addicts, and had sort of a program in place, and was designed to be a hostel that was a step towards enabling people in the appellant situation to be able to live independently. So he had his own room. He shared a bathroom and kitchen facilities, but it was a different scenario. It was accepted by Coventry in this case that he was owed the Section 193 duty. However, the third hostel informed the local authority that he'd broken the rules there too. And so Coventry, after a warning, discharged the 193 duty owed to him because of his behaviour. And so Mr. Kyle sought a review of that decision. When that was found against him, he appealed to the county court, where he was unsuccessful, and similarly unsuccessful in the Court of Appeal, where it was made clear, rejecting his arguments, that refuges are not comparable in this situation to so-called halfway houses. So Mr. Kyle in this case was relying on previous authority that had argued that you can't be made or deemed to be made homeless from, for example, a domestic violence refuge, because in that situation you're effectively still homeless, and so you can't be a combination that it can't be sort of settled accommodation for intentional homelessness purposes. And the Court of Appeal was clear that those kinds of accommodations are different to what Mr. Kyle was placed in, and so rejected the idea that he was in a similar situation to somebody in a women's refuge. And so following that, the hostel accommodation that Mr. Kyle was placed in was reasonable for him to continue to occupy, and therefore Coventry were in this case entitled to come to the view that he had made himself intentionally homeless, because he could have potentially kept staying there. So an important kind of drawing a line in terms of the sort of special status, if you like, of places like refuges, which wouldn't help not to be comparable to the situation that the appellant found himself in. So next slide is next case, sorry, is a bit more to do with duties to make decisions and to notify homeless applicants of what's going on in their housing case. This case is fresh, hot off the press. It was only published, I think, on Monday. And so hopefully I will do it justice by the summary that I put on the slides here. The claimant in this case was a single parent who'd made a homeless application in January 17, and the main housing duty had been accepted and notified to her. It wasn't until June 2020 that an offer was made of accommodation in the private rented sector. The claimant refused that offer, but did not request a suitability review. No further letter was sent by the defendant stating that a decision had been made in her case. So nothing to indicate that the duty that had been owed to under Section 193 had been ended. But a letter was sent in August 2020, headed cancellation of your temporary accommodation, advising the claimant that she was being asked to leave her current TA. Her solicitors asked for a review in October 2020, which the defendant declined to carry out. She remained in TA. The local authority then issued possession proceedings to try and evict her from her TA, at which point the claimant was assisted by the duty solicitor. And her new solicitors wrote to the defendant in May 2023, arguing that the main housing duty was still owed because the formal notification requirements for ending the duty had not been met, which the defendant did not accept. They treated that as a request for an out-of-time review, which was refused, but didn't dispute that the defendant had failed to comply with the notification requirement under Section 193. And so the main issue between the parties was whether the duty was in fact still owed. The main housing duty was still owed. And the claimant brought a JR accordingly. Thank you. And it's it's quite an interesting case for how clear the kind of court is on the importance of the duties that are prescribed to local authorities under the Housing Act, and why they matter. And I've set out the full passage from paragraph 45 here. The scheme of the Act is that once the local housing authority accepts the main duty, that duty only ceases to be owed or comes to an end in certain prescribed ways. Those ending routes or pathways are set out in the statute. There was forensic debate during the hearing about the technicality of this issue, but in fact, this is about something different: the proper and fair protection of the rights of people who are often are vulnerable and who are being supported with their living accommodation. Parliament has therefore set down carefully articulated pathways to ending the main duty. They cannot be ignored, nor should they be trivialised. They exist as a matter of safeguarding fairness and good administration. And the court found that there was no decision by Waltham Forest made that the housing duty would come to an end. Just because you offer accommodation and you advise an applicant that if they refuse, then the duty might be discharged, that still requires a decision to be made as to whether there was actually refusal or acceptance. So that offer letter doesn't automatically make the decision for you. And so sending a letter formally offering accommodation couldn't be interpreted as actually ending the duty that's owed. And nor could the second letter that the local authority sent out about refusing a late review request. And so the court rejected the argument that the duty is automatically ended if an offer is rejected. And you've got the passage here from paragraph 73, which I've set out in full here. A number of problems with the idea of automatically ending a duty without any decision being made or action following the offer. The housing authority has to assess whether there has been offer or acceptance. It must make a decision about that, and that decision there might be challengeable. If they're automatic ending, when would time run for the purposes of a challenge? You need to decide whether there has been a refusal or acceptance. And as we all know, there are cases on that, whether an offer has actually been refused or accepted. It would be puzzling if it did not need to decide whether the main duty, such a fundamental legal concept, it owed, had ended. So really, really important that is actually done and completed. And if it's not, and if a decision is not made, and the formal notification of a decision being made is notified, a recipe for chaos, as the court says here. So really, really important emphasis on the duties that are owed. So yeah, really, really broad range of cases there that we've got to sort of get our teeth into. But hopefully that kind of gives you a selection of some of the more sort of significant and pressing ones, particularly in the context of the kind of broader situation that we're in, and with the waiting list, and with so many local authorities facing real difficulties with resources. So yeah, thanks very much. I think
Thank you so much, Matthew. That was super helpful, and great to come towards the end of your speech on the quote, safeguarding fairness and good administration. Some really key principles there, and great to see the court reiterating those. So we've had a few questions in the chat.
Stephen, do you want to have a go at the first question, which was, and I don't know if you're going to know this, I don't think I know the answer off the top of my head, but would nuisance homelessness under under that bill, under the bill you were talking about, is that likely to be covered under housing legal aid, or do you think that's more of a sort of criminal context? I don't know off the top of my head. I don't know if you've got any better ideas.
Well, I certainly think that in terms of the three measures, the legal aid that you'd be looking for in relation to an appeal to the Crown Court would certainly be in relation to the possible criminal sanctioning. And so the argument would be that it would be criminal legal aid. But the question of judicially reviewing the decision to issue a notice would be under public law.
So potentially kind of cross-covering sort of civil and...
Depends which measure we're talking about.
Yeah. I'm just wondering, so for practitioners then, I mean, would you be, potentially, I guess, you're signposting somebody to a criminal solicitor in the first place, and then maybe keeping an eye on whether there's a public law solicitor who can help with JR if that's not able to be done in the same place?
Well, no, I think it very much depends on what stage you're dealing with. There are three different measures. Two of them you can appeal to the Crown Court, and the first one you can't, and that's the division.
Okay. All right, thank you.
I seem to be back.
You seem to be back. Great.
I'm not sure if I managed to say anything at all before I went mute, but here we go. Thanks for covering that question, Matt. Matt, I think that William's question might be one for you.
So, question is, how soon after an application under Part 7 does a housing needs assessment need to be completed? Or a PHP incorporating its finding made available? So I think that's really interesting. I don't know if off the top of my head, I mean, somebody else might know, but I don't think there's a sort of requirement in terms of days in the prime legislation. I suppose it's going to be sort of context dependent. I mean, in the UO case, she made her homeless application several days before she was about to be evicted and actually made homeless. So in that case, I don't think the local authority were, going to be able to fall back on that they didn't have time to do one properly because they were given more than a week's notice, I think. And then I suppose in terms of a challenge to suitability of accommodation, that the court's sort of discretion in terms of relief it might grant may well take into account an assessment of how long does the local authority have to assess somebody's case and come to a view about the suitability of accommodation that was offered. So I think it's always going to be very kind of context dependent. You would hope at least that, if you're told that there's a single parent with 3 kids, that they'll at least find accommodation that's going to be big enough for that sort of household. And they might at least make inquiries about things like access and sort of physical needs of the household with the property. So those kind of really basic questions about suitability you would hope would be able to be sorted out within a reasonable time, even if the application is being made or received, at 4 o'clock on a Friday kind of thing. So yeah, I think it will be a bit dependent on how much notice the local authority is going to claim that they had. But I don't know if there's a kind of clear answer to how soon. I think it's just always going to be in the context really.
Yeah, I had a look to see if I could find a specific deadline, but I think you're right there, Matt. Thank you very much for helping out with that answer. Either of you, I think Joan's question, I think what you're asking is that how am I interpreting this question? If you don't meet the threshold for housing priority, what help is available? I think that obviously the first avenue would be to challenge the finding that there is no priority need.
So if you have a low threshold according to the housing priority, if the question is about whether, if the question is about the sort of provision of initial Section 188 accommodation, then that obviously is a low threshold. You only have reason to believe that you may be. So there's always that sort of low threshold to fall back on and keep sort of harping on about that. If you have reason to believe that somebody may be in priority need, may be homeless, may be eligible, then that will trigger that 188 duty. And then that accommodation is there and hopefully suitable and available whilst those further inquiries are being made. So I think emphasising that low threshold is always going to be really important. And it's always important, I think, to be aware of local authorities that sort of ask the question in the converse. So instead of asking what accommodation, whether somebody may be eligible, may be in priority need, sometimes you find local authorities that will look for a reason not to believe, which is obviously not the test that's supposed to be applied, and sort of keeping an eye on that. But yeah, in those kind of 188 challenges, which I think we're all seeing more and more of, that low threshold is really important to kind of emphasize and underline and keep relying on.
Great, thank you very much, Matt. Do we have any concluding remarks from either of you? We've got a lot of thank yous coming in on the chat. Thank you so much.
Well, I didn't mention a case of Zaman, which I had in my notes. Zaman Waltham Forest, where a property had been offered in Stoke. And common sense indicated that there was a dearth of evidence as to whether or not it would have been possible to locate a property nearer than Stoke. And that was a 208 case, which was in the case of Moog that was mentioned by the Court of Appeal that should be aware of, Zaman versus Waltham Forest. I also wanted to give a nod to colleague Adrian Marshall-Williams for the Banner case. And that really is an important one where people are moved between accommodation and they don't know whether or not the authority has actually reached a decision that the duty has ended. And it's a really important point, that there should be clarity on that. And well done to Adrian for getting such a clear decision on the point.
Thank you very much, Stephen. And thank you everyone for logging on. If you found today helpful, we've got several events coming up. Tomorrow we have a community care law update webinar. You can sign up to that on our website. We'll be covering the Care Act, asylum support and other adult care services, as well as welfare benefits, some of which Matt touched on today. On the 16th of April, we've got a webinar as part of our neurodivergence series about neurodivergent lawyers. And finally, on the 15th of May, we have another webinar as part of our neurodivergence series, talking about witness handling. So thank you everyone so much for joining. We will be circulating a feedback form and we'd be incredibly grateful if you could take a moment to fill that out. And we will, of course, be circulating the recording and the slides. And on that note, thank you to our two fabulous speakers. And I hope everyone has a lovely bank holiday weekend. Thank you.